my presentation now. Andries, do you know why I'm getting the lobby all the time?
And the
Students trying to log in. I'm trying to accept them now.
Yeah. Can you will you able to assist here, or she must contact bank directly? Because I'm waiting to get
I am admitting them, Alan.
Yeah, you go.
Thank you so much. Gentlemen, can you please put off your speakers or your sound so that we don't have to listen to everybody at the same time? Can I just ask, Andries, are you still there? Is my PowerPoint presentation on now? Can I commence? Can you see that, Andries?
I can see that, Alan, yes. Just wait for 2 minutes because I can see some of them they're still on lobby. Let me just admit them just now.
Okay. Okay.
Andries, you will tell me when I can commence.
Okay, Alan. So,
Can I start?
yes, you can start, sir.
Thank you, Andries. Sorry, once again, welcome guys to our third session. We're going to be 3/4 through our curriculum after the end of today. I also said if you have any burning questions that you want to ask now, you can put on your speaker and you can ask them. Otherwise, we're going to leave the last 30 minutes of this session for questions and answers again. So if I don't have anybody asking any questions, I'm going to commence with the mortgage bond. And once again, I'm going to use what Audrey calls cheats. Audrey Gwangwa, that is the Register of Deeds Pretoria, what she calls cheats. We must just know that we must be able to draft certain clauses of a conventional bond. Ladies and gentlemen, it will be not expected of you to draft a whole conventional mortgage bond. It will be expected of you to draft certain clauses of the mortgage bond. And if we speak about the preamble or drafting how to describe the mortgagors, if it's a minor, if it's a company, if it is a company under business rescue, if it is a company, a foreign company or external company, all that is exactly the same as we discussed and studied with our deed of transfer, describing the transfer role in the deed of transfer. In our power of attorney, exactly the same as we would have drafted our description of our parties in our power of attorney to transfer property. There are different clauses. If we look at the analysis of the mortgage bond, you must be able to picture a mortgage bond. But now we've got cheats, remember? Because we got form KK and LL. KK is for a collateral bond and LL is for a surety bond. We will get to the different kinds of bonds a bit later. But if we analyze the mortgage bond, we know in the top right-hand corner there's a preparation clause. It can only be prepared by a conveyancer with his names and surname, with his LPC number. Then we have the heading mortgage bond. Then we have the preamble. Then we have the acknowledgement clause. Then we have the mortgagee. Then we have the causa. Please put off your speakers, ladies and gentlemen, so that everybody can hear me. Please put off your speaker. Then we have what we call the repayment clause and the interest and repayment clause. We have what we also call the covering continuing security clause. We must know what the purpose thereof is. We get the security that is going to serve under the mortgage bond. We must know how to describe that. And here I'm going to spot for this exam a security clause together with a waiver of preference and the waiver of preference of a usufruct or a habitatio or a lease agreement or fideicommission in favor of the bond. We'll get to that. So I must be able to analyze a mortgage bond. I must be able to prepare certain clauses in that mortgage bond. And ladies and gentlemen, if you go through your old exam papers, these questions have been asked already. Nothing new can be asked with regard to what must be, what clauses in the mortgage bond and the preparation of certain clauses in the mortgage bond. So the analysis of the mortgage bond, as I said, the preamble, the acknowledgement clause, the mortgagee, the amount obviously is very important, the causa of a mortgage bond. And if I ask you, what could the causa of a mortgage bond be? It could be anything, provided there's a debt. Remember that the prerequisites for a mortgage bond, there must be a debt, and it must be a iusta debt. There must be immovable property that's going to serve as security, and there must be the mortgage bond that is going to be drafted to give real security to the mortgagee in respect of the debt. So the causa can be anything. The cost clause, I want you to know what the purpose of the cost clause is. Special conditions. Now, they won't ask you to draft the conditions of a mortgage bond because it can be anything. If you look at the conditions of bonds, it is sometimes very lengthy bonds, which I don't agree with, because I do think that the underlying acknowledgement of debt should contain the conditions, and perhaps you can just refer there to. But the waiver of preference of a real right in favor of a bond, that is something that we're going to have to concentrate on. So once again, I say candidates must be capable of drafting certain clauses. You must be able to analyze the mortgage bond because you must know which clauses there are. The supporting documents we will get to, and then different types of mortgage bonds that we're going to look at. Now, the analysis of the mortgage bond, I've just touched on that, so I'm not going to go into that in any more detail. The following documents must accompany a mortgage bond. The power of attorney to pass the mortgage bond. It will be very seldom expected of you to prepare the power of attorney, because what is the power of attorney of a mortgage bond? Power of attorney of a mortgage bond is just a power of attorney to appear before the Registrar of Deeds to execute the mortgage bond, a copy of which is annexed hereto. So the mortgage bond will always be annexed as a copy of the annexure to the power of attorney. However, the power of attorney to waive preference of a real right in favor of a bond. Let us put an NB next to that and say to ourselves, if I have a property and that property is subject to any personal servitude, and now I'm speaking about our common law personal servitudes of usufruct, usus, habitatio, as well as over and above that, a fideicommission perhaps, or lease agreement. A financial institution will be very reluctant to give you a mortgage bond over property which is subject to a usufruct, because on foreclosure, who's going to buy property that is subject to a usufruct? Who's going to buy property that's subject to a lease agreement? Who's going to buy property that's subject to a habitatio or a fideicommission? So what the financial institutions require from you is to enter into what we call a waiver of preference in favor of the bond. Not you, the holder of the personal servitude, to waive preference that in case the property should be sold in execution on forfeiture, or if the person goes insolvent and the trustee must sell it, that this property can be sold free from the usufruct. Now, guys, it's important that you know that your property description, if there's going to be a waiver, there's different manners of doing a waiver. If you look at Regulation 41.8, it can be done in terms of a notarial deed. However, that is something that you're going to study when you do your notarial exam. Here, they don't want you to do it notarially. They want you to do it in the mortgage bond, or to prepare the power of attorney to waive preference of this usufruct, usus habitati, or fideicommission lease, or whatever the case may be, in favor of the bondholder. Your property description clause in your bond will read: a first mortgage bond security in respect of your property. Your property description will be exactly the same as we studied in deed of transfer, etc. The extent of the property in words and figures. Then furthermore, subject to the conditions contained in the title deed, so and transfer so and so. More specifically, a usufruct in favor of Alan West, identity number, status, of which usufruct, the rights of which usufruct is waived herein, as will more fully appear hereinafter. So that is how your property description is going to read. And then just before your in witness clause, you're going to also in your bond say, and also appeared before me, Alan West, duly authorized thereto by virtue of the power of attorney executed at Pretoria on such and such, granted to him by the usufructuary, Erna West, identity number, status. Where she then, the usufructuary, waives all her right, title and interest in respect of the usufruct that she has over the property in favor of this bond about to be registered in favor of the mortgagee for an amount of so and so, and then should the property be sold in execution or insolvency, it can be sold free from this usufruct. So that clause is an additional clause that will be inserted in your mortgage bond, appointing the conveyancer to appear before the Registrar of Deeds on behalf of the usufructuary to waive preference. And then sometimes the examiners don't ask you to draft that, they ask you to draft, and this, ladies and gentlemen, NB, draft a document that would be necessary to be lodged for purposes of the waiver of preference. What you have to lodge then is the power of attorney appointing the conveyancer. Now, I know there are certain model answers that's out there doing the rounds, that the model answer says a waiver of preference. I so-and-so hereby waive my preference in. That's wrong. That never gets lodged at the deeds office. The document that gets lodged at the deeds office is the power of attorney. So the waiver of preference, as I said, is very important. And then we go and we look at the different types of mortgage bonds. Now, ladies and gentlemen, you must be able to distinguish between a collateral bond and a surety bond. I haven't got time to go through the requirements and when will it be a collateral bond and when will it be a surety bond. But if you look at your old exam papers, on numerous occasions, they've given you a set of facts and they said to you, draft the necessary mortgage bond. Now, if you didn't know it was a surety bond and you did a collateral bond, you would get naught, and vice versa. So, and sometimes they ask you it in a format as follows, and this emanates now, and when I was doing my preparation for this session today, I thought about a conference resolution that was taken the year before last. And the conference resolution had the following scenario. Now, I want to sketch the scenario to you, and I want you to tell me how you're going to address this in the exams if it's asked. They say, Alan West is the owner of a sectional title unit, and Alan West is the owner of an earth in a township. He goes to the bank and he applies for a mortgage bond. They say to him, Alan West, we will give you 5 million rand provided you give that earth and that sectional title unit as security. The financial institution now instructs you as the conveyancer to register their real security in respect of the earth and the sectional title unit. How are you going to go about affording the security to the financial institution in respect of that earth and that sectional title unit. Now, the conference addressed this. Remember, for a sectional title unit, you have a specific mortgage bond, and that is a sectional mortgage bond. And there's a specific form for that, and that is prescribed Form Z. For a conventional mortgage bond in respect of an earth in a township or a farm or whatever the case may be, agricultural holding, there's no prescribed form. Can you, in a conventional mortgage bond, mortgage a section and conventional property, or let me call it a stand or a farm or whatever the case may be? And the answer is no. So how are you going to register this security for purposes of the loan that the financial institution has afforded Allen West? Now, the answer is simple, ladies and gentlemen. You will register a principal bond over either the stand, the earth, or the sectional unit. And then for the same debt, you will register what we call a collateral bond, so that you get all the security under a mortgage bond, but it will be two mortgage bonds. It will be a collateral bond and I said surety bond. It will be a principal bond and a collateral bond. So that is how you're going to address this. And this is the type of question that can be expected of you in the exams, because this is what a conveyancer's work amounts to. The financial institutions don't know, the deeds office knows, and you, the conveyancer, knows. So that is what a collateral bond is. It is a further bond affording further security in favor of the same mortgagee by the same mortgagor for the same debt. There will be a principal bond or there will be a principal debt. That's a collateral bond. A surety bond is where somebody else stands in, a third party stands in and gives his property to you, not to you, to the financial institution or the mortgagee for purposes of securing a principal debt. So I wouldn't go into the exams without being able to differentiate between a collateral bond and a surety bond. The next type of bond, and there's no English terminology, this comes from our Roman Dutch law called a kustingsbrief, but a kustingsbrief is a bond that is registered for the balance of purchase price. And then you're going to tell me, but why? What makes this kustingsbrief, or what makes this bond for the balance of the purchase price so unique? The uniqueness lies in the provisions of the Insolvency Act. If the bond is registered simultaneously with the transfer of the property in favor of the transferor or a third party for the balance of the purchase price, then it gets preference on insolvency. And there I refer you to section 87 to 89 of Insolvency Act. So there, once again, we looked at the kustingsbrief. The other bonds that we get is the covering bond. Now, once again, it has been asked in the exams, and strangely enough, I've severely criticized when examiner asks a question as follows: what do you understand under a covering bond? You know, you can tell the examiner anything. You can say it could be a bond that you give somebody for Christmas, and the examiner must give you full marks. Why? Because the examiner asked you, what do you understand? And that is what you understand. So you must get full marks. Now, I'm being facetious now. I don't think they will see it that way. How the question should be posed is, explain in your own words what a covering bond is. Then you will tell them this is a bond that is being registered for a debt that does not exist, or for the full debt which does not exist at the time of registration. These, for instance, a bond where you go to a financial institution and you say, I want to register a bond for overdraft facilities. Your amount of your bond will fluctuate, because you will go and say, give me a bond for 500,000 Rand. But when you register it, you don't owe the bank 500,000 Rand. It is a covering bond to cover 500,000. And why I'm harping on a covering bond and a fixed amount mortgage bond, because there's a difference when we have to do part payments or when we have to do cover reduced. So just remember that as well. Indemnity bonds and debenture bonds, I'm not going to look at that at this point in time. That is something that is very unique, and I will not go into that in the exams. However, participation mortgage bonds, and here all that I want you to study under participation mortgage bonds, because that is covered by the Collective Investment Schemes Control Act of 2002. And anything that you have to know about that is set out in Chief Registrar Circular 15 and 21 of 2003, as well as CRC 4 of 2012. Now, I do hope you have those circulars. If you haven't got those circulars, get hold of those circulars, because the Collective Investment Schemes Control Act is one of the statutes that forms part of your syllabus. And they can ask you for what is the minimum amount for which a participation mortgage bond can be registered. In favor of whom is a participation mortgage bond registered? Can a participation mortgage bond be ceded? If it can be ceded, with whose permission can it be ceded? And to whom can it be ceded? So those are the questions that can be posed with regard to participation mortgage bonds. Ladies and gentlemen, and that is what I want you to know under mortgage bonds. So let us summarize mortgage bonds quickly now, just for purposes of the exams. What must I know under mortgage bonds? I must know the analysis of a conventional mortgage bond and be able to draft the clauses therein. What I will spot in the conventional mortgage bond is the security clause and the waiver of preference clause in the mortgage bond or in the power of attorney. I must be able to differentiate between surety bonds and collateral bonds and covering bonds and participation mortgage bonds, and know how they work in practice. When I come to sectional mortgage bonds, I'm not doing sectional mortgage bonds now. Why am I not doing sectional mortgage bonds? Because we're going to do that when we do our sectional title lecture next week. Okay, so I'm going to step off mortgage bonds, and I'm going to go over now to substitutions of debtor. Now, what is a substitution of debtor? Substitution of debtor is when the transferee, the person acquiring the property, is going to take over the debt under a mortgage and under an existing mortgage bond. Where property is transferred from one owner to another, the debtor may be substituted, provided application is made and the bondholder consents thereto. Now, ladies and gentlemen, financial institutions don't like this business of substitutions of debtor because there's no new mortgage bond, and there's somebody that has to go through all the processes. So in many instances, they will rather require you to cancel the existing mortgage bond and register a new mortgage bond. But let us look at the different types of substitutions of debtor that we can be confronted with. And the first one is, you will remember we ended off last week with partnerships. The dissolution of a partnership in terms of section 24. Can you please put off your speaker, sir or madam? Please put off your speaker. So last week we ended off with partnerships, and we said when a partnership dissolves and the property vests in the individual partners, can you please put off your speaker, ladies and gentlemen? Please put off your sound. Thank you. We said if a partnership dissolves, and we looked at the forms of dissolving of a partnership, we said by virtue of agreement, by insolvency, by death, etc. And then we looked at how we're going to draft it, and if it goes to a new partnership, how that's going to be done. If we are going to do a transfer by endorsement in terms of section 24(1) of 24 Biz 1 of the Deeds Registries Act to the individual partners. And those partners are going to take over the mortgage bond. We're going to substitute them in terms of Section 24 Biz 3. So what am I saying to you? I'm saying to you that you must study Section 24 Biz 1 together with Section 24 Biz 3 with the dissolution of a partnership, meaning that if the mortgage bond must not be cancelled on the dissolution of the partnership, but the partners must all be substituted as the debtor in their individual capacities under that mortgage bond, you're going to bring an application in terms of Section 24 Biz 3. What form are you going to use? Unfortunately, the Deeds Registries Act does not prescribe a form for 24 Biz 3. You will use prescribed form T and you will adapt prescribed form T. But remember now, you're not going to be able to substitute the individual partners if one partner has been declared insolvent or if one partner has died. Because what financial institution will give a consent that the dead partner can be substituted as debtor or the insolvent partner can be substituted as debtor? This 24 Biz 3 will only apply in instances where they dissolve the partnership by agreement and each one of them is going to get his share in the partnership property. I hope that you understand that and the supporting documents that must go together with the 24 Biz 3. Then we come to 45(2)(c). Now, ladies and gentlemen, you can remember last week, I said to you, I will not go into the exam room without having a thorough knowledge of the transfer by endorsement in terms of Section 45(1), Section 45 Biz 1A, Section 45 Biz 1B, Section 45 Biz 1 capital A, small a, Section 45 Biz 1 capital A, small b. I will also now not go into the exam room unless I know how to substitute the debtor in the case of a transfer by endorsement in terms of those Section 45s. Now, last week we said for each one of these substitutions of debtors in terms of Section 45(2), there is a prescribed form. It will either be prescribed form T or it will be prescribed form BBB. So those are your two prescribed forms that you're going to use for a substitution of debtor. The question is usually posed in the following manner. Draft the necessary application and deal with the mortgage bond in the most cost-effective manner. The bond must not be cancelled. Then you know in that instance there's going to be a substitution of debtor in terms of Section 45(2) for purposes of substituting the debtor. You have those prescribed forms with you. You have to adapt it. You must know how to draft it. Those are things that I cannot teach you. You must be able to, and I can't stress this more, you must be able to draft. However, I want you to understand the difference between a substitution of debtor in terms of 24 Biz 3, 45(2)(c, and 57. The big difference in 57 and those others are the following. 57 can only be used, ladies and gentlemen, if you are transferring the property which was mortgaged by a deed of transfer. I say again, an NB. Section 57, prescribed form W, can only be used when you're going to substitute the debtor on the transfer of property, which property is being transferred by a formal deed of transfer, not a transfer by endorsement. NB, not a transfer by endorsement. And how many times I was privy to this in the exams, that examiners ask you to draft the necessary substitution of debtor when somebody dies or somebody gets divorced or they change their matrimonial property regime. And what form do you use? You use form W and you use Section 57. Now, last week, and I think it was Sipu, somebody that asked me, will I get no marks for that answer? If you bring an application in terms of Section 57 and it was supposed to be 45(2)(c), They will draw a line right through it, irrespective if your parties are correct or whatever the case may be, because you applying the wrong section to the statement to the facts or the scenario that you have been provided with. So I want you, and this is one of the sections that I would have a very good working knowledge of when I get into the exam room. Section 57, they usually ask you to draft the application and consent, or they ask you in which instances can Section 57 not be applied. And ladies and gentlemen, well, unless it's been asked in the first paper, if it's been asked in the second paper, all that you have to do is turn to Section 57, and it'll tell you in which instances a substitution of debtor in terms of Section 57 cannot be applied. So you must know the contents of Section 57 for paper 1. For paper 2, you will have it. You will also know that it's prescribed form W that you're going to use for the substitution of debtor. It is a application and a consent for the substitution. I don't know how much more I can explain about substitutions of debtors, but I once again say this goes hand in hand with your transfers by endorsement and your cost-effective manner of substituting a debtor under a mortgage bond if the property is being transferred by a formal deed of transfer. As I've already said, substitution of debtor in terms of Section 24 verse 3, there's no prescribed form, but you use prescribed form T. I've already said that. Substitution of debtor in terms of Section 45 2C, there you've got prescribed form T and prescribed form B. Section 57, NB. The candidates must be capable of drafting a substitution by using prescribed form W and having a sound knowledge of the contents of Section 57. When are you going to use Section 57? When can you not use Section 57? And how to draft the provisions of the substitution of debtor. Ladies and gentlemen, and that is mortgage bonds and substitutions of debtor. So what is difficult, and I get this so often that people phone me or they text me or they email me and they say, how do I study mortgage bonds? This is how you study mortgage bonds. The analysis of the mortgage bonds, the different mortgage bonds, and the waivers of preference of real rights in favor of the mortgage bonds, and the substitutions of debtors. That's mortgage bonds. I hope this has made it a bit more clear to you how to prepare for the exams with regard to mortgage bonds. As I said, I haven't touched on sectional mortgage bonds. We're going to get to that. Ladies and gentlemen, now, and as I said, please forgive me because we're going through this fairly fast, but I told you right from the outset, this is a finishing course. This is not a preparation course. We're just polishing the marble now. We're just telling you what you must concentrate on. And unfortunately, if I had, and really I do need so much time to be able to explain this to you in detail, but that's not the purpose of this 4 2-hour sessions that we have. So next, ladies and gentlemen, we come to dealings with mortgage bonds. Now, how do I go about studying the different dealings with mortgage bonds? And how do I draft these documents? Now, I say once again, when we come to dealings with mortgage bonds, for all the dealings with mortgage bonds, there is a prescribed form. You must know where to find the prescribed form, or you must know there's a prescribed form. You must know how to populate that prescribed form, and you must know under what circumstances you're going to do this dealing with a mortgage bond. Is it peremptory? Is it not peremptory, or whatever the case may be? So the first dealing with a mortgage bond, no, sorry, I just want to go one back. The first mortgage bond, or dealing with a mortgage bond, is the cancellation of the mortgage bond. Ladies and gentlemen, that is prescribed, and I'm looking now at page 10, point number 7 of your handout of the how to prepare for the conveyancing exam. The first dealing with a mortgage bond is the cancellation of a mortgage bond. Are they going to ask you to draft a cancellation of a mortgage bond? No, because all that you will do is rewrite prescribed form MM. However, you know how they ask you that? In the first paper, they say, in which instances is it not necessary when you transfer property to cancel a mortgage bond? I say, repeat. They ask you in the first paper, when transferring immovable property, when is it not necessary to lodge the mortgage bonds registered over that property for disposal or to cancel those mortgage bonds? Now, your answer here too is contained in section 56 of our Deeds Registries Act. And here we're dealing with, here we're looking at sales and execution, expropriation transfers, transfers by order of court, transfers in terms of section 34(2) of the Administration of Estates Act, sales by a company which has been liquidated and is unable to pay its debts. If it's able to pay its debts, the mortgage bonds must be lodged. So you must, when you're looking at cancellation of mortgage bonds, you're looking at prescribed form MM, and you're looking at section 56 when it is not necessary to lodge those bonds for disposal. That is cancellations. The next one is the release of property. Now, the release of property from the operation of a mortgage bond is when you have different properties registered under a mortgage bond, or you're taking out a certificate of registered title for a portion of the property and you want to release that portion out of the operation of the mortgage bond, you can do that. However, there is something that I want you to look at, and that is the provisions of section 55 and 56. Write this down. Section 55 and 56 of the Deeds Registries Act. When you release a person and his property from the operation of a mortgage bond. I repeat, when is it necessary for me not only to release the property from the operation of a mortgage bond, but also the person? Now, by way of an example, you and I have different properties and we register a mortgage bond in favor of First National Bank for 100,000 Rand, and we give my property and your property as security under that mortgage bond. So the mortgagors is going to be Allen, West, and Sipu. They are jointly and severally bound in favor of the financial institution for amount of 500,000 Rand, and they give property 1 owned by Allen and property 2 owned by Sipu. I want to sell my property now. We don't want to cancel the mortgage bond, but I want to sell my property. How are we going to deal with this sale of my property and a mortgage bond that is registered over my property and your property? If the financial institution is amenable to releasing my property because the rest or your property, Sipu, is still sufficient security for the amount owing under that bond, they will then, first of all, say, our operative clause of our release will be, do hereby consent to the release of the property of so-and-so from the operation of the bond and the release of Allen West from the operation of the mortgage bond. So you're releasing person and property, because you cannot be a mortgagor under a mortgage bond without being without the mortgage bonds securing your property. However, section 56 says if you're going to release person and property, the other co-mortgagor must consent to the release of Allen West. So what are you lodging at the deeds office? If Sipu and I are joint mortgagors of different individual properties, and I want to get out of this mortgage bond, the bondholder is going to consent to the release of my property as well as me in person, and my co-mortgagor is going to consent, a different consent, but lodged in the same lodgement cover, consenting to the release of me from the operation of the mortgage bond. This has been asked. I'm scared that it's going to be asked again. So concentrate. The normal release is as straightforward as a normal cancellation, but the release of person and property, that's a subtle nuance that you have to take cognizance of. Waivers of preference. Now, we're not speaking about the waiver of preference that I discussed with you, of a waiver of preference of a usufruct in favor of a bond. This waiver of preference is also in terms of Form MM. And here we have waiver of preference to rank prior or waiver of preference to rank pari passu. What does pari passu mean? To rank together, standing on equal stead with regard to the ranking of the mortgage bond. So once again, what do I expect of you? I expect of you to know when you're going to waive preference to rank prior, and when will you waive preference to rank pari passu in respect of the ranking of the mortgage bond. But that is also Form MM. Cession of mortgage bonds. NB, NB, NB. You know where you guys lose your marks with cessions of mortgage bonds? Your heading, you cannot write consent to cession, because it's not a consent to cession. It's an act of registration. Once again, you're using Form MM, but you must be able to differentiate between two types of cessions: an out-and-out cession and a cession as security. An out-and-out cession is almost, if I can explain to you what an out-and-out cession is where I sell, or I bequeath, or I donate, or you inherit a mortgage bond. I hope you understand this. You go into the shoes of the mortgagee. We're not speaking about mortgagors now. We're speaking about mortgagees. By way of an example, I have a mortgage bond over your property. So Sipu is the mortgagor, the guy who borrowed the money, and he borrowed the money from Alan West. So there's a mortgage bond registered over Sipu's property in favor of Alan West. Alan West dies, and he says, I bequeath all my earthly belongings to my 3 children. Deal with the mortgage, or deal with the mortgage bond. How are you going to deal with that mortgage bond? You're going to cede that mortgage bond. You're going to use prescribed Form MM. So the executor in Alan West's estate, how are you going to describe him? You're going to describe him as Peter Mashlangu, in my capacity as executor in the estate of the late Alan West, duly authorized by letter of executorship so-and-so, being the estate being the holder of mortgage bonds so-and-so, passed by so-and-so in favor, to hereby cede and make over all the right, title and interest in respect of the above bond to A, identity number status, B, identity number status, C, identity number status, they being entitled thereto in terms of the will of the late Alan West, dated so-and-so, who died on such and such a date, signed 2 witnesses. That is a cession of a mortgage bond. However, 2 exams passed. They said, same scenario that I gave you now, same scenario, but they said, Alan West's will says the following: I bequeath all my earthly belongings to my 3 children, subject to a usufruct in favor of my wife, so-and-so, and they mention her by name. Deal with the mortgage bond. I've spoken fast now. I want to give you the scenario again because I want you to understand this. Alan West is the mortgagee. Sipu is the mortgagor. He borrowed money from Alan West, 500,000 rand. A mortgage bond is registered over Sipu's property. Alan West dies. Alan West's will says, I leave all my earthly belongings to my 3 children, subject to a usufruct in favor of my wife. The only asset that Alan West has, and it's an asset that he has, not a liability, it's an asset that Alan West has, is a mortgage bond over Sipu's property. Deal with the mortgage bond. How are you going to deal with this mortgage bond? Guys, I want to throw it to you now, and I want you to please give me an answer. Please put on your mic if you got an answer. Give me an answer, because even if you make the mistake now, it's good that you make it now if it's a mistake, because you're not going to make this mistake in the exams. Anybody want to give me or offer me a way of dealing with this mortgage bond now? Please come in. Somebody just tell me how you're going to deal with this mortgage bond. Yes.
Ellen?
To whom am I speaking?
It's Sophia.
Sophia, tell me.
The mortgage bond will be ceded to the wife.
To the wife, and what about the children?
I'm not sure.
If you say that, you're right. Just tell me how you're going to describe your operative clause of your mortgage bond. If you can just briefly tell me how you're going to describe the operative clause of your mortgage bond, of your session.
Well, it's stuck at the moment.
Okay, don't worry, but you are right. Can I ask you, and I'm going to ask you a leading question. Why are you saying you're going to cede it to the wife? I then, in my will, and I'm being facetious now, in my will I said I bequeath it to my 3 children, subject to a usufruct in favor of my wife.
The wife has a usufruct, and the asset will then go to the wife based on the usufruct that she has over the property.
If it was, and I'm asking you, if this was land, how would have you done it then? If I had an earth and I said I leave all my earthly belongings to my 3 children subject to a usufruct in favor of my wife.
The wife would have had right of use over the property while she was alive.
Yes, but she's alive now. How would you deal with the land? You would transfer the land to the 3 children, subject to the usufruct in favor of the wife. Am I right?
Yes, that's correct.
Why is there a difference with the mortgage bond? And I want you, because it's good you explaining this to our other attendees now. Why are you not doing it the same as a piece of land?
Because it's an asset that Ellen West had over the property, and that now goes to the wife. Sorry, I'm not sure how to explain this.
Yeah, okay, but you're correct. Your operative clause, the reason why I'm not ceding it to the children subject to the usufruct in favor of the wife is because the wife is going to be entitled to the fruits. And remember, a mortgage bond is not land. It is a debt. It is actually a real right. So she's going to get the fruits hereof. And after her death, the corpus will then, whatever is left of it, will be ceded to the children by her executor. So your operative clause of your session will be to hereby cede all right, title, and interest in the above mortgage bond to, let's call her let's call her Erna West, identity number, unmarried, as usufructuary, in terms of a will of Alan West, who died, dated so-and-so, who died on such and such a date. But you have to describe her as usufructuary, because she's not getting the bond as a whole. She's only getting the fruits of the bond. Do you understand that? She's only getting the fruits of the bond, because the bond is not land. If it was land, you would have transferred it to the 3 children subject to the usufruct in favor of her, and when she dies, obviously it accrues to the bare dominium owner. So I want you to be able to understand sessions of mortgage bonds, the different types of mortgage bonds, and how you're going to draft the operative clause. Let me just, in the same scenario, I have a mortgage bond over Sipu's property. I have a hell of a lot of debt, and the sheriff attaches this mortgage bond. And he decides that he's going to sell this mortgage bond in execution for purposes of the debt. If that is the case, the sheriff will cede this mortgage bond to the person who has bought it, and your causa will be exactly the same as you would have drafted a causa of a deed of transfer for the sale of property in execution. You will say there was a writ. You will say who the parties were to that writ, and that it was sold in execution on such and such a date. Now, therefore, so and so is entitled to the above mortgage bond, and this will be obviously an out-and-out session. So just understand, it can also, a bond can also be sold in execution for the debts of the mortgagee. Part payments and cover reduced. This is the other two aspects that you have to look at for purposes of the exams. Now, ladies and gentlemen, cover reduced and part payments. And this is why I harped when we did the mortgage bond. If you have a mortgage bond for a fixed debt, meaning money lent and advanced, bond for balance of purchase price, that debt does not fluctuate. Now I want to cede that mortgage bond. I can't cede the mortgage bond for 500,000 Rand or sell the mortgage bond for 500,000 Rand if that mortgage bond is only worth 200,000 Rand now. Do you agree with me? So by way of an example again, I have a mortgage bond over Sipu's property, 500,000 Rand. Sipu has paid off. He now owes 200,000 Rand. I now die, and that mortgage bond must be ceded to my children. Can I cede the mortgage bond for 500,000? No, I first have to do a part payment of that mortgage bond. Register a part payment, a part payment of 300,000 Rand, the balance now owing being 200,000 Rand. And that 200,000 Rand will then be ceded. However, if this wasn't a fixed mortgage bond, but this was a covering bond, meaning a bond which fluctuates in the amount owing. It doesn't go from 500,000 Rand to naught. It goes 500,000 Rand, 200,000 Rand, 400,000 Rand, 100,000 Rand, back to 500,000 Rand. And I want to cede that mortgage bond now. But the person that wants to take cession of it doesn't want to take it for 500,000 Rand. He only wants to take it for 200,000 Rand. Then you register what we call a cover reduced. So you must be able to understand and differentiate between when am I going to register a cover reduced and when am I going to register a part payment. Do we understand that? The operative clauses, I'm not going to go into that because you have got examples thereof in any case. Then we come to the consents to issue certificates of consolidated title or certificates of registered title that we're going to get to, and the partition transfers, the dealings with partition transfers that we've already dealt with when we looked at section 26. And I said, remember, section 27 is the section that you're going to apply when you're going to do partition transfers and the mortgage bonds must be substituted. There's one that I also want to, and this comes up fairly often, and it's called a variation of terms of a mortgage bond. Now, this is in terms of section 31S. Write this down, 31S. 31S says the terms of a mortgage bond can be varied. However, the following terms cannot be varied. You cannot vary the mortgagee and the mortgagor. You cannot vary the security. You cannot vary the causa. You cannot change a covering bond to a fixed mortgage bond. You cannot alter the amount inclusive of the cost clause of a mortgage bond. So what can we do with a variation of terms in terms of section 31T? We can vary the conditions or the interest or the repayment clause. That we can vary. However, there's a prescribed form for a variation of terms. But if you didn't know that there's prescribed form VV and they ask you this question and you drafted some or other document, I want to say to you, line through 0, although you got a prep clause. Because you have to follow prescribed form VV. It is in the form of agreement. I, the mortgagor, and you, the mortgagee, hereby enter into an agreement whereby we vary the terms of the bond, that this condition will be substituted, or the interest rate will be increased from 10% to 15% payable in advance, or whatever the case may be. So once again, please take cognizance of the prescribed forms. And just once again, a hint, or what Audrey calls a cheat. If there isn't a specific prescribed form, you use MM. If there isn't a specific prescribed form, you use MM. I'm not speaking about sectional titles now. I'm speaking about conventional mortgage bonds. If there's not a specific form, you use MM. So what have we done now, ladies and gentlemen? We've done mortgage bonds, we've done substitutions of debtors, and we've done dealings with mortgage bonds. Specific dealings with mortgage bonds. Yes, there are other dealings with mortgage bonds, which we're going to do under the next heading, which we're going to look at now, and that is obviously sundry applications for the endorsement of title deeds of immovable property and or mortgage bonds. Okay, so NBNB. Now we're looking at our different sundry applications. So just to summarize again, we've looked at our deed of sale. We've looked at our deed of transfer. We've looked at our power of attorney. We can draft all that, clauses in that. We've looked at our different types of transfers, our prescribed form F, G, H. We've also then looked at transfers by endorsement, the whole of section 25, 45 and 24, etc., etc. We've also now done the mortgage bond. Sorry, I'm in Zoom. So we've looked at all that, and then we did the mortgage bond, we did the substitution of debtors, we did the dealings with mortgage bonds, and now we're going to look at the sundry applications. Am I going to get any of these sundry applications to register or to prepare in the exams? Most definitely. The first one, section 41B. Guys, section 41B is a section which is sometimes misinterpreted, because if you, and I'd like you to take the time when you're preparing for the exams just to read section 41B, because it has a limited application. It has a limited application. It says if there's an error in the name of a person, the description of the person, the conditions in a title deed, then you can bring a application in terms of section 41B. So it has a limited application. I have been I've advocated this for a long time, that it is a sad situation where conveyancers ask their clients to bring an affidavit to swear to the Lord above that the extending clause of their title deed is wrong. I don't believe that a man in the street knows what an extending clause is. Whether his registration division of his property is not JR, but it's JQ. How the hell can he swear to the Lord above that it shouldn't be JR, it should be JQ? So usually a section 41B is an application and affidavit brought. However, if a conveyance, the conference has made it very clear that the conveyancer can bring an application so authorized in terms of a power of attorney, but then he will not bring it under oath. He will bring that application to the Registrar of Deeds to say, I, Alan West, in my capacity as conveyancer, duly authorized by Peter Mashlangu, identity number status, by virtue of a power of attorney afforded to me, and that is usually the power of attorney that I'm transferring the property, to hereby confirm that He is the owner of the following property. The extending clause of that property reads as so, which is incorrect. It should be so and so. This will not have the effect of transferring a right. There are no other deeds that need to be amended, and it is signed by the conveyancer. That is the more appropriate way to do it. So what am I saying with section 41B? Can it be asked in the exams? It has been asked in the exams in the past. Whether it's going to be asked in this exam, if it is, hallelujah for you, because it is as easy as falling off your chair to draft an application and affidavit in terms of section 41B. Section 17.4. Now, I want to make it categorically clear that section 17.4 of the Deeds Registries Act is not peremptory. It is not obligatory. It is a matter of choice whether your client wants to have his title deed updated with a change in status or not. Now, what do I mean by change in status? Let me, by way of an example, once again say to you, when I bought the property, I was unmarried. I thereafter married my wife in community of property. Is it obligatory for me now to bring that section 17.4 application before I can transfer the property? No. I can transfer the property because if you look at the definition of owner, either me or my wife, with the consent of the other, is the owner of the property. So it is neither here nor there. In terms of our common law, my wife is the owner of the property subject to my consent in terms of section 15.2a. But just on that point, I bought the property and I bought the property while I was unmarried. Thereafter, I married in community of property, and thereafter I got divorced. Can I now bring an application in terms of section 17.4 to disclose my status as unmarried? I repeat the question, and I'm going to ask you once again, one of you must answer me now. You must come in and answer me. I bought the property in 2015. It's registered in my name as unmarried. I thereafter, in 2016, got married to my wife in community of property. However, in 2019, my wife and I got divorced. So now I'm unmarried. Can I now bring an application in terms of section 17.4 to disclose my status as divorced to the Registrar of Deeds? Anybody tell me whether I can bring an application in terms of section 17.4 to change my status to divorced? Please come in. Make your mistake now.
No,
or
you
don't
can't.
Yes?
I say you can't because when you became married in community of property, she automatically became 50% half share became hers.
So what must I do now before I can transfer the property if I'm busy transferring the property now?
So you would, on your divorce, then you should do section 45 biz, which one is it?
You're quite right. You're quite right. It depends on what the divorce court order said. Did the divorce court order say I get the property? Did the divorce court order say she gets the property? What would we do if the divorce court order is silent with regard to this immovable property?
Then you both become co-owners.
Co-owners in terms of section 45 biz 1 capital A small a. Wonderful. We can't bring a section 17.4 to transfer ownership of property. It is only what we call a factual endorsement to update an existing title deed if I am, let us say I was married out of community of property and we got divorced. And I don't want my title deed to say I'm married out of community of property. Yes, then I can bring it. Let's say I was unmarried and now I'm married in community of property. Can I bring the application? Yes, I can, because my wife, by virtue of operation of law, did become owner of the property, so it's a factual endorsement. If I'm married, which marriage is governed by the laws of a foreign country, and my title says unmarried, Remember, in the past, we didn't recognize customary marriages. So in the majority of old title deeds, the parties are still described as unmarried, which is now, in terms of our Recognition of Customary Marriages Act, totally wrong. So therefore, we can update our title deed in terms of Section 17.4 if a customary marriage was entered into. If you've seen the latest court case, the Constitutional Court case on Muslim marriages, they say Muslim marriages are now recognized in South Africa. The legislator has been given 2 years to get an act aboard, but they say you cannot describe a Muslim marriage now as being unmarried. It is married in terms of Muslim rights. So many title deeds, and you even will look at the Chief Registrar's circulars, say conveyances, you have a choice. You can describe a Muslim marriage as being unmarried or married in terms of Muslim rights. This legislation has now changed it and said, no, you cannot describe a Muslim who has married in terms of Muslim rights as being unmarried. So once again, look at the provisions of Section 17.4 and know what documents must be lodged with your application in terms of Section 17.4. Obviously, all interdependent deeds must be amended at the same time. You don't have to amend all the deeds throughout the Republic of South Africa, but if it's a transfer and a mortgage bond, you will lodge, and then you will have to lodge proof of your change in your status. Section 25.3 is our next application. Now, guys, you know, I've been involved in conveyancing since 1972, and I'm sure that is before many of you were born, or the majority of you were born. And in my whole career, I've never seen an application in terms of Section 25.3. I've just got a message here. Andries, if you are still listening, I've received a message, and that was the telephone call that was coming in. People are trying to log in and they can't log in. Can you please, Andries, are you still there? Andries? Is there anybody from Lead that is available to allow people to log in? Because I can't log you in from my side. Andries? Guys, I apologize. I'm the messenger here, and those people trying to log in, I'm sorry, I cannot help you. And I hear the ping, 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 ping. I cannot, from my side, I cannot allow people to log in. So I'm sorry. If there's anybody that can assist me, that maybe knows more than what I do about this, that allows people in, anybody that could help me with this? Then I'm going to continue. Section 25.3, as I said, in my more than 45 years of conveyancing, I've never seen an application like this. But I have to take you back to Section 25.1 to explain to you 25.3. 25.1 is the scenario is as follows. I die, and as in my will, and here I'm trying to rule from the grave now. In my will, I say I bequeath this property to the children born or to be born from my daughter. I don't want to give it to my daughter. I say this property I bequeath to the children born or to be born from my daughter. I die. Now that property, my property that was registered in my name, must be transferred. And the vesting clause of that transfer in terms of this will be, the property will be transferred to Larissa West in trust for the children born or to be born from her. So she's actually only holding it in a fiduciary capacity until all her children are born. Now, the question that has been asked to conference, when will those children be determined and ascertained? Now, you know, in the past, we could say if a woman has a hysterectomy, she can't have any more children, or when she reaches the age of 65, she cannot have any more children. However, the case law as it stands, those children will only be determined on the death of Larissa West, alternatively, if the court determines that she cannot procreate any further. If that has been determined, the children or their representatives bring an application to the Registrar of Deeds in terms of Section 25(3), whereby they say that in terms of the order of court or because of the death, the property now vests in A, B, C, and as if they've taken formal transfer of the property. So Section 25(3) is also a type of transfer by endorsement, but it is a factual endorsement that takes place subsequent to a vesting of property in trust for children born or to be born from a person. But Section 25(1) goes further. It can also be for the children born or to be born from a marriage. Then that property will be registered in Alan West and Erna West in our capacities as guardians for the children born or to be born from our marriage. When will those children now be determined of the marriage? Will they be determined on the divorce? No, because Alan West and Erna West can get remarried. So it's either on the death of Alan West or the death of Erna West, or where the court decides that we cannot procreate any further. If that is the situation, then obviously we will bring the application again to vest the property in the persons that the children born from Alan West and Erna West. So once again, I say a Section 25(3) application will always be preceded by a transfer where the property is held in trust for the children born or to be born from a person, or in the guardians in trust for the children born or to be born from a marriage. And then you will bring the application. The supporting documents that you have to lodge with that, I'm going to refer you to the necessary literature that you have to go look at the supporting documents. Section 44, this is an important one, and sometimes the question is very ambiguous when it comes to Section 44. I don't know if you've already gone through your old exam papers, but they say, they give you a scenario where they say A is the owner of a farm. On resurvey, the farm, the extent of the property was determined to be X and not Y. A new diagram was framed. Draft the necessary document to rectify the error. Ladies and gentlemen, Section 44 is not an error. It's not an error. It is where the property has been resurveyed and the extent of the property is now not as it is on the existing diagram, but on a new diagram for the property that has been resurveyed. So once again, the application is brought by the owner of the land, whereby he says the property was, he brings an application. Let me just, by way of an example, there's no prescribed form for this application. It is, let's say it's my land. In the top right-hand corner, preparation clause, heading, we're not going to say application in terms of Section 44 of the Deeds Registries Act 47 of 1937 as amended. We're going to say application. Then we're going to say, I, Alan West, identity number status, do hereby apply to the Registrar of Deeds in terms of Section 44 of the Deeds Registries Act for the endorsement of deed of transfer whereby the following property was held. Property description, and I declare that the property has been resurveyed by virtue of diagram so and so, and the extent of the property is no longer this, but it is this. Signed. That is your application in terms of section 44. A new diagram has been drafted, the property has been resurveyed, and obviously the title deed must be updated, not amended. It's not an error in registration, it is an update. While I'm speaking about an error in registration and an update, please also note on the difference between section 17.4 and 4.1b. Guys, I still have conveyancers phoning me on a daily, not on a daily basis, on a weekly or bi-weekly basis. And they say, the property was bought by A and he never told me that he got married out of community of property before I registered the property. So I registered the property in his name as being unmarried. He now comes to me and he says to me, my title deed describes me as unmarried, but I'm actually married out of community of property. Are you going to bring a 17.4 or are you going to bring a 4.1b? You can't bring a 4.1b because it wasn't an error in registration. Sorry, you can't bring a 17.4 because it was an error in registration. If I changed my status after registration, then I can bring a 4.1b. If I changed my status before registration, then it is an error in registration. And that is why I tell conveyancers, and when you've passed your exam, I hope this sticks with you, that before you execute a deed in the deeds office, you know what you're supposed to do? You have to phone your seller and say, sir, are you, or ma'am, are you alive? Because if he's dead, you haven't got a mandate anymore and you can't transfer the property. The property vests in the master and then the executor. You should ask your seller, sir, has your status changed? Because you in your title deed, you refer to as married in community of property. But if you've divorced, I cannot transfer this property. Similarly, with your transferee, you must ask, sir, ma'am, haven't you got divorced? Sir, ma'am, haven't you got married, or whatever the case may be? Because remember, your deeds and documents that you lodge for registration, you now prepare the documents, but you only lodge it in a year's time. I'm exaggerating now. Everybody wants it quicker, but sometimes it takes years before you get it registered. You have to find out if the status of your parties are still as at date of registration and not as at date of execution. Okay. Section 58.2. Guys, here, I don't want to touch on section 58.2 now. I'm going to discuss section 58.1 and section 58.2 when I discuss the Insolvency Act with you. Because we know if you are declared insolvent, all property that you acquired before insolvency or during insolvency for a further period of 10 years automatically vests in your curator or trustee or whatever you want to name him. And you cannot deal with that property because you're not the owner thereof. You have been divested and it has been vested by operation of law in your trustee or whatever the case may be. Once you're rehabilitated, and that rehabilitation, and I'm not speaking about automatic rehabilitation in terms of section 127A, I'm speaking about you apply for your rehabilitation before the 10 years is over. Now there's a rehabilitation order that's been issued. Can you now deal with that property? No. The trustee of your insolvent estate must transfer the property back to you, and it is transferred in terms of an application in terms of section 58.2. But I'm going to touch on that again when we deal with the Insolvency Act. Section 68.1, NB, 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 NB. I want you as well to differentiate between section 68.1 and section 68.2. Section 68.1, the wording of section 68.1 says, if a personal servitude has lapsed for any reason whatsoever, the holder of the servitude or anybody on his behalf can apply to the Registrar of Deeds for the noting of the lapsing of that personal servitude against the title deed of the property. And the title deed of the servitude, if available, if available. Section 68(2) says, if a personal servitude has lapsed by virtue of agreement, then it must be done by virtue of a bilateral notarial deed, but that is your notarial examination. And then conference has extended the provisions of section 68(1) to include reversionary rights, preemptive rights, fideicommissions that have lapsed for any reason whatsoever. You can bring an application in terms of section 68(1). However, the application that you're bringing, you must know whether there is transfer duty implications. Put an NB next to section 68(1) and say, I must be able to tell the examiners whether, if I'm going to bring an application in terms of section 68(1), whether there is going to be transfer duty implications, and must I lodge a transfer duty receipt. There will only be transfer duty implications if the lapsing of the servitude has the effect of increasing the value of the property. Now, immediately you're going to tell me any servitude that lapses increases the value of the property. However, it will not increase the value of the property if the servitude has served its time. What do I mean by the wording has served its time? What I mean by that is, let's say I have sold my property to you for 500,000 Rand and I reserved a usufruct in favor of myself, and I die. That usufruct, the value of the property is going to escalate, but I've died, so the servitude has served its time. There's no actually increase in the value. However, what people usually do, I sell my property to you, let's say my property is worth 5 million Rand. I sell my property to you for 2 million Rand and I reserve a usufruct in favor of myself. Now, after a month, because you and I are friends, I cancel my personal servitude. I cancel it in the form of what we call a waiver. I don't want it anymore. So I don't enter into agreement with you. I renounce my usufruct. Obviously, there's going to be an escalation in the value of the property, and you're going to pay, the owner of the land is going to pay transfer duty on that. And you know what SARS further says? Because I'm renouncing that usufruct, it is tantamount to a donation, and there's donation tax payable on it as well. So beware of trying to evade tax by cancelling a personal servitude, because there is going to be transfer duty payable, and there's possibly going to be donation tax as well. So look in which instances you're going to cancel a personal servitude, look at the supporting documents that you're going to lodge, as well as what the transfer duty implications are. Section 93(1). Here it refers to change of name. Now, if you read the wording of section 93(1), remember you got your act in front of you. It says a change of name of a person. I just want to read it to you because I think it refers to partnership as well. Let me just get section 93 in my act. Section 93 says, if any person or partnership whose name appears in a registered deed or other document has changed his or her name, the registrar shall, on written application by that person or partnership, accompanied by proof of the change of name. Now, I must explain this to you. Let us say I'm Alan West, and I don't like the surname West anymore. I want it to be East. I have to go through a process by going through Home Affairs and publishing it in the Government Gazette. The Deeds Office will only accept proof in the Government Gazette that I've changed my surname from East to West. And then I must bring an application to the Registrar of Deeds in terms of section 93 under oath to say that I've changed my surname from West to East in terms of government notice so-and-so. It will not have the effect of a change in persona. There are no other deeds that need to be amended, etc., etc. But a woman can, and I've written an article, if you ever have time, I've called it a rose by any other name. And what I say there, a woman has the divine right of changing her surname at will. Let us say, I get married to a woman today. She has the option of assuming my surname, retaining her surname, or taking on a double-barrel surname. It's also not obligatory that she updates her title deeds. When she transfers the property, she can say formally so-and-so and use the surname. When she gets divorced or when I die, she once again has the divine right of reverting back to her maiden name without going through the formal process. I, on the other hand, am stuck with West. Even though I get married to a woman with the surname of East, I cannot take on her surname unless I go through the formal procedures. However, that is a change of name of a natural person, government gazette, except a woman who gets married or who gets divorced. A partnership, and I'd like to know now from you, a partnership was called the ABC partnership. There's no change in persona, but they now want to be known as the CDE partnership. What proof are we going to give the Registrar of Deeds to prove that they are no longer the ABC partnership, but the CDE partnership? Anybody want to come in? What proof am I going to submit to the Registrar of Deeds that this partnership has changed its name from ABC to CDE? Anybody? Make your mistake now, it could be asked in the exams.
Not SIPSI.
Say again? No, partnerships are not registered with CIPC. Anybody else? Come on, guys. You're writing the exam in 2 weeks' time.
Partnership agreement.
Partnership agreement is still the ABC partnership. They've just changed their name. They haven't changed their partnership agreement.
Partnership resolution?
Yes, hallelujah. What's your name? Because I want to give you an extra mark in the exams.
It's Magdalene Georgiana.
I'm only joking. Okay, a partnership resolution. Exactly the same. Let us say it's not a partnership, it's a church. And the church has changed its name from A to B. Exactly the same A resolution of the church, okay? Which will also fall within the ambit of person. Now, Section 93 has been amended, and Section 93 was amended in 2013 to bring it in line with the New Companies Act. The New Companies Act does not provide for a change of name of a company. So they had to incorporate it in the Deeds Registries Act. But remember, the old Companies Act, which was repealed on the 1st of May 2011, did make provision for a change of name. And if you go look at the old Section 44 of the old company, the repealed Section 44 of the old Companies Act, there, if a company had changed its name, all that you did, you lodged your proof of change of name, if you want to call it the CIPC or the document that changed its name, in a yellow cover without an application. If the company has changed its name after the 1st of May 2011, an application in terms of Section 93(1) must be brought by the directors of the company. So please, for this exam, I think there was in 3 exams ago, there was a question 22, I still remember it, question 22 of the short question paper, and they asked questions on the change of name of a company. And you know what? They in that question, some of you most probably have looked at that question. They said the ABC company has changed its name to the CDE company. There's mortgage bonds registered over the property. Must the mortgagee consent to the change of name of the company? And you know what? The majority of candidates said yes. remember, a change of name is a fait accompli. It's done. It's gone. Now, if you want to insist and you go to the bondholder and you say, you know, this company has changed its name from ABC to CDE, and they say, you know what, we don't like the name CDE, therefore we're not going to consent thereto. That'll be absurd, won't it? Because the company has already changed its name. So it's just a factual endorsement that is brought on the title deed and the mortgage bond. They do not have to consent thereto. Those are the sundry applications that we are confronted with in the deeds office. However, there are certain other applications that have to be brought in terms of the Administration of Estates Act. And that is section 39.2, 39.3, and 40, and a change of name or close corporation and the conversion thereof. 39.2, guys, you know, this has also been asked on a fairly ongoing basis. And I think in the last exam, there was to differentiate between 39.2 and 39.3. Now, 39.2, I can only explain to you by way of a scenario. And this is, I'm going to give you the scenario now, and then you'll tell me, okay, now I understand it. I have property and I die, and I say in my will, on my death, my wife will have the usufruct over this property. And after her death, the property must be sold and the proceeds must be divided amongst the children still alive at that point in time. My children alive at that point in time. I'm going to give you the scenario again. I die, I have a property. Let's call it a farm. I have a small farm. And I say, on my death, my wife has the usufruct over this farm. After her death, the farm must be sold and the proceeds must be divided amongst my children alive at that time, or amongst my children. The question is now, the estate must be wound up. The executor wants his fees because he wants to walk away out of this estate. He doesn't know how long my wife is still going to live. She might live for another 40 years. And then he will never be able to administer this estate. So the question is, can I transfer the property to my wife? Or can the executor transfer the property to my wife? Can the executor transfer the property to the children subject to the usufruct in favor of the wife? The answer to both those scenarios is no. So to administer this estate, the executor is going to apply to the Registrar of Deeds in terms of section 39.2 to record the terms of the will against the title deed because the heirs are unascertained. And when the wife dies, a new executor or the existing executor will have to sell the property and divide the proceeds amongst the children. So I hope that scenario has explained the provisions of section 39.2 to you. Section 39.3 is also recording the terms of the will against the title deed of the property. These are 39.2, 39.3, and 40 are all caveats. They're not transfers of ownership. It is merely to wind up the estate. 39.3 is, I die and I bequeath the property to my 5 children, but there is no money in this estate and the children do not have the financial means to take transfer of the property. And the executor wants to wind up this estate and he can't now wait till 10 years till the children have, so he asks the Registrar of Deeds to record the terms of the will against the title deed of the property. And for that and when the children have the means to take the transfer, then the executor will pass transfer to them. Look at the supporting documents over and above the title deed, the application. We need a consent in terms of section 39.2 or 39.3. We need a section 42.1. We need the will that must be lodged. Then we come to section 40. This one gets asked on, it's almost every third exam. I see there's an application in terms of section 41B of the Administration of Estates Act. Guys, this is the instance when a mortis causa trust has been created in a will. Now, mortis causa trust can only be created in a will. We know that because that is a trust that comes into existence on the death of the trust creator. Inter vivos trust, the property will be transferred by a formal deed of transfer. A mortis causa trust can only be transferred, not transferred, endorsed. The title deed can only be endorsed in terms of section 40. And you know, listen to me what I'm saying now, because this is a conference resolution and this could be asked in your first paper, because many conveyancers do not know the difference between section 40 of the Administration of Estates Act and the transfer to a trust. So let us say I die and I say my property, on the death of me, the property must go to my children. Should any of my children be under the age of 25, the property will vest in the Allen West Family Trust. And then I set out the terms and conditions of the Allen West Family Trust, because the Allen West Family Trust is not a inter vivos trust, it is a mortis causa trust. And let us say the conveyancer did not know that section 40 of the Administration of Estates Act is peremptory. You cannot transfer it by a deed of transfer, you must endorse it in terms of section 40. And he goes now and he transfers the property to the Allen West Family Trust. How do I rectify that? How do I rectify a transfer that has been effected in terms of a formal deed of transfer, however it should have been endorsed in terms of section 40? You know what? I'm not going to give you the answer. I want you guys, and this is one of the questions that we're going to answer next week, but I want you to do your research because I'm worried that this question is going to be asked in the exams. Do your research. I'll give you a tip. It is in your conference resolutions. It could be in the last 4 years' conference resolutions. And believe me, where do the examiners find new questions for the upcoming exams? In the conference resolutions. Change of name of a company or close corporation and the conversion thereof. What did I say? Where will you find the answers to how do I do a change of name of a company or close corporation, or the conversion thereof from a private company to a public company, or from a close corporation to a company? In Chief Registrar's Circular 28 of 2013. 28 of 2013. I will not go into the exam room unless I have a good, well-oiled knowledge of Chief Registrar Circular 28 of 2013. Guys, it is now 20 to 5. We only have 20 minutes now for questions and answers. I have not held by my program, so I cannot do certificates of title. So we're going to do certificates of title, sectional titles, and statutes next week. With my intro this afternoon, I also said to you, Anton Tron is going to be available for the first 10 minutes of my Zoom next week to answer any questions that you have that you might be worried about. And maybe this is the time that you should ask him leading questions, whether it's necessary for you to know how to draft a statement of an account, transfer duty, which tariffs do I need to know, etc. So, okay, that is for next week. Next week we're going to do certificates of title, but I want you to prepare certificates of title for next week, guys. I want you to look from section 34 to section 46. And you must know, remember, there's a prescribed form for every certificate of title. They're not going to ask you to prepare the certificate of title. They're going to ask you to prepare the application. Then you must know which section to apply. Okay, that's for next week. Questions and answers. Over to you guys. please ask me any questions pertaining to the work that we did today or the previous 2 sessions that we had. Anybody, please come in, put on your mic, ask me questions. And I can't believe that there are no questions.
Just to break the ice.
Yes, please.
No, I'll actually ask you, why these conveyancers who are calling you every week,
Yes.
is there a consultancy fee that you charge them? Because they get a lot of money.
You know what my colleague Anton Tron said to me, Alan West, when you were a training officer in the Department of Land Affairs, they bothered you but you got your salary from government. So you didn't mind helping them then. However, now, Alan West, you're working for yourself now. You must generate your own funds. So what I'm saying to you now, sir, is the following. If they bother me or they send me a lengthy email and I say to them, you know what, I can assist you. However, my consultation fee is this per hour. I don't think it will take more than 30 minutes. And the majority of them come back and say, thank you, Alan. I will arrange a Zoom meeting, and they do it. Some of them just ignore me and they go to somebody else and they get the answer perhaps there. I hope they get the correct answer. So what I'm actually saying to you, if it's a short question like so-and-so and I can answer them with the answer of no or yes or see Chief Registrar Circular 28 of 2013, I do that because it doesn't take time. But if I have to research something because sometimes their clients want an opinion and I draft an opinion at my fee. And yes, I am asking a consultation fee if it takes time for me to answer. But you know, I believe conveyancing has been good to me for more than 40 years and I must give back to conveyancing as well. So I'm not going to try and make money out of you. If I can assist you with a brief answer, unless you want an opinion, I will charge you. But that's, sorry, break the ice. I do it, and yes, Anton lambastes me for doing it, but that's me. Questions?
Hi, Mr. West, can you hear me?
No, I can't hear you. You must speak into your mic.
Can you hear me now?
I hear you now.
So I just wanted to ask, in terms of party descriptions with regards to trusts, in the power of attorney and the deed of transfer. So you know how you'd have like your IT, you'll have a number / the year.
Yes.
After that in brackets. So for Durban, for instance, it'll be D, or for Pietermaritzburg N. Does that have to go those brackets after party descriptions for transferor and transferee?
Yes. But they will give you that number. They will give that suffix to you. So, but it has to, and it's good. While you're speaking about trusts, because there was a court case, and it specifically referred to Section 16 of the Deeds Registries Act. Is a trust a person? And the question was no. You have to actually get a definition of person to include a trust. However, that court case said you can vest property in the Allen West Family Trust. However, do that and you believe me, you're going to get a problem at the deeds office, because the deeds office wants you to vest the property in the trustees for the time being of the Allen West Trust with an MT or IT or whatever the case may be. And I say to the deeds office, you know, how can it be anybody else but the trustees for the time being? Why do you want for the time being in? Because that is actually tautology. But you know, I take the road of least resistance. But in the exams, if you write the ABC Trust, or you write the trustees of the ABC Trust, or you write the trustees for the time being of the ABC Trust, all is correct because the examiners know. And I also perused the memo and I say, the following is all acceptable. So, but when you in practice, and you know what? I hate what I'm saying now, but I now use the trustees for the time being of the ABC Trust, because I don't want to get a note and I have to go to the examiner and I must argue with him and I must say to him, please sir, it's not actually right, look at this, and he says to me, sorry, I'm not going to help you, and my client is sitting on my neck and he wants this transaction registered. So I hate what I'm saying, but when you are a conveyancer, you're going to follow what I'm saying to you now in any case. More questions?
Alan, can I ask you two?
Yes.
We were talking about a usufruct over a bond.
Yes.
The fruits of the bond, would that
Yes.
just be the interest, or would it include capital repayments as well?
It will only be, she's only entitled to the interest. That is the fruit of the bond.
Right. And then section 25, when we were talking about children born or to be born, does that include children that could be adopted?
It depends what the intention was with of the testator. If he says children born or to be born from Larissa West, it cannot be adopted children.
Okay.
And I'm saying to you now that I've never seen this in 45 years, but there is that option. Why would you, in your will, bequeath the property to the children born or to be born? You don't even know that this little rascal that's going to be born is going to be a washout or whatever. But that's me speaking. So no, it doesn't include adopted children. No.
Thank you.
Something else, guys? Guys, you've paid. You still got 10 minutes. Use it. Lose it.
In what scenario? When
Hello?
oh.
Okay. Come in, sir.
Okay. When you were saying there's no specifically prescribed form, used form MM.
Yes.
What in mind do you have?
I have in mind that Form MM, if you look at the heading of Form MM, it says consent to the cancellation, the release, waiver of preference, etc., etc., etc. So any consent from a bondholder, let's say to a amendment in terms of Section 41B. Remember, the bondholder must also consent to the rectification of the bond. So what form are you going to use? Because there's no form for that. What I actually mean by that is you're going to utilize Form MM to draft your consent unless there is a prescribed form. So any bondholder's consent, unless there is a prescribed form, you use MM. It's just a guideline. It's me speaking.
Mr. West, does that include consent for a consolidation, for example?
Consent to consolidation depends, and when we get to consolidations, remember, and while you're on it, we get a consent in terms of Section 40 in brackets 3 and a consent in terms of 40 in brackets 5 in brackets A. The one for 40 in brackets 5 in brackets A, there's a prescribed form, and the prescribed form there is WW. For the consent in terms of prescribed form, in terms of Section 43, 40 in brackets 3, there's no prescribed form, so you use MM. I usually say 40 in brackets 3 is MM, and 40 in brackets 5A is WW. You just turn around the MM and it becomes WW. That's how I understand. That's how I studied it. Are you with me?
Okay, yes, thanks so much.
Remember, MM, WW, turn it around. But you must know when you're going to apply 40 in brackets 5A and when are you going to use 40 in brackets 3. That we're going to do next week. Questions? Guys, time is now becoming, and I say this every time is now becoming of the essence. You guys must please Now is the time that you start working out old exam papers. You know one another, I'm sure. Try and get working groups together and say, this week we're working out September 2019's exam paper. And I'm going to send my paper to you, and you're going to send your paper to me, and I'm going to mark you, and you're going to mark me. That's how you assist one another in this exam. And it's to your benefit. Please, guys, work out exam papers, because I believe that the working out of exam papers after you've got the knowledge will assist you, and you will be able to do that in the exams as well. I think there's no more questions. Yes?
You mean you have to literally answer those questions?
Yes. You must write out it as if you were sitting in the exam room. Yes. Because it's only thereby will you know that you can answer those questions. You know, sometimes, sir, you think, you know, this is easy. This is a 93. I can do a 93. Alan spoke about, I can do a 93. Then you come in the exams and you're going to sit and you're going to wonder, where do I start? What do I write? What is the operator? Must it be a affidavit? Mustn't it be an affidavit? What must be contained in the affidavit? If you're answering this now already, then you'll say, oh, that was that question. Oh, I remember. And then you'll have an idea how to do it. Maybe you've got your own ways of doing things. Extending clauses, an example. All those extending clauses in the old exam papers, I will write them out over and over and over again, so that when I get something like that in the exams, I'm going to say, extending clause, no problem. And I just rewrite it. Application in terms of section 45, no problem. I've done 15 already. That's me speaking. That's the way that you have to prepare for this exam. There's no other easier way than write. You cannot study conveyancing out of a book. You have to be the practical. The theory, yes. The practical, you have to be able to answer by writing it out over and over. Even if you do 20 section 45 applications, it's going to be so easy in the exams. It is going to be a walk in the park.
Oh, lastly, I think Sipo had a question.
Say again, sir?
I think Sipo had his hand up, Sipo.
Sipo, you had your hand up, Sipo?
Yes. Yes, I had a question which always, I'm a bit confused, man, especially when it comes to section 41B and 93.
Yes. Okay, can I explain the difference between 41B and 93? Okay. 41B is an error in registration. Okay. 93 is a change after registration of your name. Let us say, let me Sipu tell you, I changed my name from West to East before registration, but the conveyancer still registered it in West. That is a 41B.
Okay.
However, I changed my name after registration from West to East, and I go to Home Affairs and I get it published, then I can't bring a 41B because it wasn't an error. The deed was correct when it was registered. Yes. Now I have to change that name in terms of section 93.
So do you have to lodge all the proof?
All the proof.
Application 93.
The proof in the form of the bondholder's consent. Sorry, I say bondholder's consent. You need a bondholder's consent for my change of name. No, it's a fait accompli because it has been published. It has been published in the Government Gazette.
Yes.
So, okay. Sipo, I hope you've got my book, or you've got notes from Harvey or whoever the case may be. When studying section 93, you must know what supporting documents must go with it. So you must know the format and what supporting documents. So it's actually 3-tier. You have the section, you have the application, and you have the supporting documents. For every one of these sundry applications, you have the section, you have the drafting of the document, and the supporting documents. That's how you have to study dealings with mortgage bonds, sundry applications, transfers by endorsement, etc., etc. The section, the drafting, the supporting documents.
Perfect, 100%. Thank you so much.
Sipu, and I want to see you in the deeds office driving a Porsche.
Thank you, Mr. Lennon.
Okay, see you guys next. Not see you. Hear from you next week,
We
guys.
receive.
Yes.
What I'm saying, we receive. That's
Sorry,
what
I didn't.
I'm saying we receive on that Porsche wish. That Porsche.
If it's not a Porsche, maybe a Lamborghini. Guys, enjoy. I can't tell you to enjoy the next 2 or 3 weeks because you're not going to enjoy it. You must now shoulder to the wheel. Please study hard. And any questions that you have, even if you have to phone me during the week, you're more than welcome to phone me. If it's a burning question, I'm here to assist you. I want to see you pass this exam. I want to see you drive that Porsche. There's an absolute need for conveyances. All the best. See each other next week, guys. Enjoy. Bye-bye.
Bye.
Bye.